As you can see, we have just opened a number of new offices. We're delighted to say that we now have an office in Xi'an and in Changsha. So that brings now to 13 our offices around China. Okay, so this is hopefully a very interactive platform for everybody. What I would like is that people get involved, ask their questions. Ask your question at any time. If you type it in, please, that would be great. We have everyone on mute because there'd just be way too much noise and a whole lot of confusion. So if you have a question, type it in. If it's pertinent and relevant at that time, I'll drop it into the speaker's flow and they'll answer it immediately. Otherwise, we'll save it to the end. And if we don't get to it on the day, I will hand it to the presenters and they'll be able to get back to you in due course. What I would like everyone to do, just to make sure that you're all receiving me loud and clear, is if you could click on the Raise Your Hand button. So I'm just highlighting that now. If you could just click on the Raise Your Hand button, and that will allow me just to make sure that everybody is receiving loud and clear. I see some attentive students this morning raising their hands. Great, so basically that means that the platform is alive and well. Okay, so as I said, put your questions in here. If you have any question, that could be a query about the topic. It could be asking for some follow-up afterwards. If you're maybe having a problem with the sound or something like that, feel free to ask any question at any time. All right, I'm going to put everybody's hands down. The other thing that we'll be doing is we'll be asking polls. We want this, as I said, to be interactive. We want people to get involved and we want to help people on the spot. So the first example of a poll, which I always ask, the first one is, where are you? So I'm going to launch this poll now. So please just click on your answer. You should be able to see a poll now. If you could just click on the correct answer for you. That's nearly everybody. I'll just give it another couple of seconds. So please just click on wherever you are. So this will also give the speakers a little bit of help to understand who is online and just tailor how they speak to people and just give them a better understanding. All right, so we'll drop these sorts of polls in as the event goes on. So that's pretty much everybody. I'll close that, and just so you can see. So we can see that 2/3 of people are in the UK outside of London. Again, I say this every time, but that's really, really great for us at CBBC. One of the reasons that we're doing these webinars is to be able to reach people who wouldn't ordinarily maybe travel for an event like this. So we feel that all members deserve this content and that this is a great way for us to get that content across to people. All right, brilliant. So I shall close that and we'll go back to where we were. The next thing now is really just to move on to our speakers. Our topic today is contracts and contract negotiations. Our first speaker, Catherine Shen, received her LLB in Economic Law from the East China University of Politics and Law in 2001 and her LLM in International Economic Law from the University of Warwick in 2003. Before joining Broad and Bright as a partner in 2012, Ms. Shen worked at a PRC governmental institution, a law firm, a multinational company, and Herbert Smith LLP. Ms. Shen's primary practice areas include foreign direct investment, mergers and acquisitions, private equity, hotel investment and management, labour and antitrust law. Concerning foreign direct investment and mergers and acquisitions, Ms. Shen has advised foreign investors ranging from Fortune 500 multinational companies to private businesses across a variety of sectors including telecommunications, internet, information technology, automobiles, mining, real estate, travel and leisure, healthcare, clean energy, education, financial services and manufacturing. Wow, that's quite a mouthful. I should have practiced that. Her advice and assistance have covered the acquisition of shares or assets of Chinese companies, establishment of foreign invested enterprises in China, restructuring of existing foreign investment in China, as well as general corporate and commercial issues. And as I said before, Catherine is also very experienced in covering hotel investment and management law and antitrust law. So we're really thrilled to have Catherine. Thanks for that. Our second speaker, just to also give him a quick introduction, Mr. Hao Jiang. Mr. Hao Jiang is also from Broad and Bright. He graduated from Peking University with an LLB and LLM degrees. He then earned a JD degree, magna cum laude, from Villanova University School of Law. and an LLM degree in taxation from New York University School of Law in the US. Subsequently, he worked with leading international law firms in their Washington, D.C., New York City, and Shanghai offices for years. Currently, Mr. Zhang is a partner at Broad and Bright. Mr. Zhang concentrates his practice on tax, foreign investment, and private equity. He previously represented large multinational companies and financial institutions, including JP Morgan and Chase, GE, Morgan Stanley, Pfizer, China Development Bank, CLSA, Carlyle, Amway, SPX, Cargill, Sailing Capital, and Samsung. Moreover, he has various publications in tax, trust, and investment areas. So I think we're in very, very good hands this morning. Really now, I just want to hand over to our presenters. Catherine, are you out there? Let me find you. Where are you? Catherine, can you hear me?
Yes, can you hear me?
Yes, Catherine, can hear you loud and clear. That's terrific. So I'm going to hand over to you, and as you want me to change the page, just tell me, but basically I hand over to you, okay?
Okay. Thank you, David. Good morning, everyone. Welcome to today's live CBBC webinar. My name is Catherine Shen, and sitting alongside me is Mr. Hao Jiang. We are both partners of Broad and Bright and specialize in general corporate and commercial matters with a focus on helping foreign clients investing and doing business here in China. Hao is a tax specialist with experience in all kinds of PRC tax-related matters. Our topic today is contracts and contract negotiations in China. There are slides on our website accompany this webinar. Questions can be asked at any time during the course of today's session. There's a facility on the website for you to do that. We'll try to deal with some of the questions during the session if there's enough time to do so. If there are any questions we did not manage to get through during today's session, we may be able to respond, but we'll follow up later on. Next slide. David, next slide. Here are the 6 aspects of issues we will touch on today during today's session. Basic rules to avoid pitfalls in contract making, key terms in commercial contracts, execution of a contract, contract negotiation, and litigation versus arbitration, and the PRC taxes applicable to different types of commercial contracts. My colleague Hao will walk us through the last bullet point. Next slide. Contract making. There are some basic rules for you to follow in order to avoid pitfalls in contract making. First of all, knowing your counterparty, knowing who you are dealing with. This may sound very obvious, but in reality, this can show how important this basic rule is. Second rule is to negotiate favorable terms to the extent that's possible. And the third rule is to ensure safe execution of the contract to make sure it's valid and legally binding on both parties. So before we go to the next slide, maybe we can ask our first poll question.
Okay, I've launched that now. It should pop up on everybody's screen. That is the question, what type of legal entity do you have? So just again to gain a bit of an understanding of who our listeners are, whereabouts are you in the whole stage of engaging with China, or what suits your business? Yeah. Okay. We'll just give it another couple of seconds. Please have a click, everybody. Quite interesting results, actually. But not everybody has voted. Now we're getting there. Okay, we'll give it another couple of seconds, and I'll close that now. It's pretty clear. And I'll share the results. So almost 70% of people today actually have no entity in China, which I think is perhaps makes it, might suggest they don't have a physical staff presence or physical presence there, which means this contract issue is even more important. Over to you, Catherine.
Okay, that's interesting. Okay, so now we'll look at the first rule, knowing counterparty. And you have different counterparties for different types of contracts. For example, whether it is a distribution contract, a supplying contract, an agency contract, a lease contract, or a JV contract, or even just a service contract. So the information you will require from the counterparties varies depending on what types of contracts you are dealing with. Next slide. Before you sign a contract with your counterparty or even start a business relationship with a counterparty, it may be necessary to carry out a preliminary due diligence on the counterparty to check its legal status, to check its financial health, to see whether it has the required financial ability to perform the contract they will sign with you, and to check its operational conditions. This does not have to be a full legal and financial due diligence. For example, you can ask for a copy of its business license to see whether it is validly existing, and you can get a basic sense of its professionalism by seeing whether your counterparty's email address is a company email address or ended with at 136.com or yahoo.com. In terms of communication style, is it changing? The contact person, is it changing? All these basic points will give you a gut feeling as to your counterparty's professionalism if you have never met with them before. As to the financial health issue, you may ask for a copy of a bank reference letter from both of your counterparty and its shareholders. The bank will issue such a letter upon the request of the counterparty to confirm that it is in good financial standing. Alternatively, you may also check the financial statements and auditor's reports of your counterparty to get a sense of the financial health of your counterparty. Sometimes a simple Google search may even help. We have handled a case whereby a Chinese company wants to buy a large amount of commodity from a foreign company. So they sent over a contract and invited the foreign party to come to China for a commercial negotiation. And everything looks fine, and the contract was very fairly drafted, and the ordered amount was big. So the foreign company was very excited to come. The only requirement, the payment term is fine in the contract, but they only require 1% of the quality warranty deposit paid by the seller upfront. So this actually, everything looks fine, but after doing a simple Google search, they discovered that this company is actually a scam in the market. They have played the same game with several foreign companies. So they will trick you to come to China and ask you to pay some small deposit or ask you to pay a very small notary fee, etc., just for this small amount of the fees. So sometimes if you have never met with a counterparty, sometimes maybe it's necessary to do a simple Google search of the counterparty. Negotiating favorable terms. Here are some basic rules. If you want to have a contract which is favorable to you, it's not the legal department's responsibility only. Inputs from the business and finance teams are required to make sure that the contract makes commercial sense for the company. You need to know your bargaining position and power depending on the specific circumstance of the matter. In China, we have Party A and Party B. Party A refers to the party who pays. So Party A has superiority in demanding more favorable terms in the contract for them. And also, the drafting party always has the advantage to get a more favorable contract. So to the extent possible, you always we suggest you always ask your legal counsel to draft a favorable contract for you. Whether the contract is a one-time contract or a long-term contract. All these factors will affect your ability to negotiate for a more favorable contract for you. Here are some preliminary legal considerations before you sign a contract with your counterparty. For example, are there any mandatory qualification or license requirements for the counterparty to enter into the transaction with you? If it is for a distribution contract, if it involves a regulated product in China, you need to make sure that your counterparty has a required distribution license for the product that's in question. And are there any other regulatory approval, registration, or filing required for the contract? This is also a key issue to check before you sign the contract with your counterparty, because China's legal environment, generally speaking, is a very regulated legal environment. There may be various approvals, registration required for your particular type of contract. So the absence of getting any of these required approvals may lead your contract become invalid. Next slide. I think before we go into a detailed discussion of the key terms in commercial contracts, I would be interested to see what type of contracts you have ever signed with a Chinese counterparty. So, David, maybe we can try the second poll question.
Absolutely. I've just launched that now. So what types of contracts have you signed? So just to get an understanding, what kind of contracts all of our listeners today have signed with China or Chinese companies. Okay, we'll give it another couple of seconds. It's, there's one clear winner at the moment, although it's not about winning. Another couple of seconds. Okay, I think I'll close that, and you'll see it's pretty self-evident from most people that people have signed service contracts. Over to you, Catherine.
Okay, interesting. Okay, now we will take a look of some of the key terms in commercial contracts. Payment terms. Payment terms is always one of the key terms to consider in commercial contracts. As a payer, you may need to consider whether there should be some conditions or milestones to be satisfied before you make the payment. If the payment is made by a Chinese legal entity, you need to consider the implication of foreign exchange procedure applicable to the kind of payment you are making, and try to ask for a longer payment period. As to the right to set off, as the payee, the party who received the money, you obviously do not want to give this right to the payer. Every payment claim should be independent from each other. It's not subject to any counterclaim or set off. As a payer, maybe it's better to have the right to set off the payment against any other amounts owed by the payee to you. Liability for breach of contract. We will have a more detailed discussion of this issue later. Term and termination. This is also key provision to pay attention to in commercial contracts. You need to remember that extension and renewal of a contract essentially creates new obligations on the parties. So make sure that renewal and extension will be subject to mutual consent of the parties, but not an automatic extension or renewal. Dispute resolution, it's the same. We will talk about this issue in more detail later. Choice of law. Except for certain category of contracts, it is permissible under PRC law for the parties to a foreign-related contract to choose a foreign governing law for the contract. The category of contracts for which PRC law must apply include a JV contract, a contract for Sino-foreign cooperation, cooperative exploration and exploitation of natural resources, or a contract of buying Chinese companies or assets. For this type of contract, PRC law must apply, as there's no room for you to choose a foreign governing law. But for other types of foreign-related contracts, as long as the parties agree, you are allowed to choose a foreign governing law, for example, English law or Hong Kong law or even New York law. So you may ask how to determine what it is a foreign-related contract. A contract will be considered foreign-related if at least one of the parties is foreign, i.e. not PRC registered, or the subject matter of the contract is wholly or partly outside of China. If it is a contract with no foreign-related element, for example, is signed between two PRC legal entities, then PRC law must apply. There's no room for you to choose a foreign governing law for a domestic contract. Language. There's no explicit legal requirement in the PRC law that a commercial contract with a Chinese party must be written in Chinese. In reality, the foreign party wants the English version to be the governing version, and the Chinese party wants the Chinese version to be the governing version. So the common compromise in practice is that the parties will accept that both versions will just be equally valid. But if the contract requires approval by the Chinese authorities, the Chinese text will carry more weight than the English version in practice, especially if it is to be litigated in China. And even though you say that the English version is the governing version, the Chinese authorities may not accept this provision and demand an amendment of this provision to say that both versions are equally valid, or even the Chinese version is the governing version. Signing date is important because in most cases, the signing date is the effective date of the contract. The signing dates need to be made consistent across the whole contract. Otherwise, the contract will take effect from the latest of the various signing dates. Next slide. Next slide. Remedies for breach of contract. The remedies, there are four types of remedies which are expressly available under the Chinese law. These are damages, specific performance, cure of defective performance, and liquidated damages. Damages are the most common form of remedy for breach of contract in China. The right to claim damages arises from either express statutory provision or from the parties' agreement. As a general comment, the principles on damages are not very different from those under the English law or from the common law system. One practical point to bear in mind is that although the quantum of damages awarded by an arbitral tribunal in an offshore venue with a common law majority will be higher than a Chinese court would award in an identical case, even though both are applying the Chinese law. Yeah, so this may be a practical consideration to bear in mind when you choose whether to go for offshore arbitration or for PRC arbitration. There are three clear limitations in the PRC law in relation to damages. For example, the non-breaching party has the burden to prove the actual losses it has suffered due to such breach. And the non-breaching party need to show that the party in breach foresee or ought to have foreseen the loss in question, i.e. the loss cannot be too remote. And also, the non-breaching party, the innocent party, has an obligation under PRC law to mitigate the losses it will suffer or it has suffered. Otherwise, it will not be able to claim compensation for the losses it didn't take measures to mitigate. For specific performance, this is generally available to non-monetary payment obligations, non-monetary, non-peculiar debts. But but in practice, the specific performance is very difficult to obtain, both from a Chinese court or from an arbitration tribunal. When I say non-pecuniary debts, it means if the monetary damages are available, specific performance, generally speaking, will not be awarded. As to the third remedy, cure of defective performance, this is an additional remedy which in effect provides for a specific performance where the performance of the contract is defective. This usually applies in the area of sale of goods. The breaching party bears a liability for breach of the contract in the form to repair, replace, redo, or return the targeted subject goods to the extent that the buying party can establish the breach. As to the fourth remedy, liquidated damages, the parties to a contract may freely agree on a contractual liquidated damages to be paid as a result of a particular breach by a party. An important point to note about liquidated damages in China is that either party may apply to the Chinese court or arbitration tribunal to have the amount of damages adjusted to reflect the actual losses incurred. So that means if the actual loss suffered by the non-breaching party is lower than the liquidated damages, the non-breaching party may apply to the court to increase the liquidated damages. On the other hand, if the agreed liquidated damages is excessively higher than the loss suffered by the non-breaching party, higher than 130% of the actual losses suffered by the non-breaching party, the breaching party may also apply to a PRC court to reduce the amount of the agreed liquidated damages. Subject to certain statutory limitations under PRC law, it's important to capture liabilities under the contract and avoid unusual risks. PRC law does not recognize punitive damages. All damages must be compensatory in nature. However, it does recognize indirect or consequential damages caused by the breach. For example, loss of opportunity or loss of profit. Therefore, it's important to put a cap on the total liabilities under the contract and exclude claims for incidental, indirect, and consequential damages. For example, the cap can be set at the total dollar amount of the goods or services being sold under the contract. When drafting the clause on exclusion of liabilities, you need to express the limitation or exclusion of liability in very clear language. Present the exclusion clause prominently in the document and highlight in bold or underlining. PRC law prohibits exclusion of liability for personal injury or loss to property caused by willful misconduct or willful or gross negligence of the breaching party. In addition, the exclusion of liability clause is also subject to a broader principle of good faith and fairness. So it is fair to say that there's some degree of uncertainty in relation to the exclusion of liability clause under PRC law. So it is possible for PRC court to find exclusion of liability clause to be void in situations where it is unreasonable, manifestly unfair, or otherwise contrary to moral, commercial, or social standards. Next slide. Execution of a contract. Verbal contract should be avoided because it does not give you enough protection to enforce the rights established by the contract. When you circulate the contract, make sure you are building some backup wordings in the front page of the contract. For example, you can say that the draft is subject to, this is the draft, or the contract is subject to final legal business review, or subject to internal approval, etc. If the signing is not done face by face, it's usually preferred for the counterparty to sign the contract first. And also, don't forget to check the signatory authority. Under PRC law, the legal representative of the company has the authority to sign documents on behalf of the company. If it's an authorized representative, you need to see a power of attorney granted by the legal representative. A unique issue to mention in China is that don't forget to ask for the contract to be stamped by the company CHOP of the counterparty. Personal signature, theoretically speaking, it also constitutes valid execution by a counterparty, but in practice, it's more important to have the contract to be stamped by the company CHOP of a counterparty. Next slide.
I've got
contract negotiation.
Catherine, I'm going to
based on our experience in helping.
Catherine, are you there?
Sorry?
Quick question here from Jack. I think you went through some of it when you talked a little bit about the punitive issues. He said, how does tort play into PRC contract terms?
Tortious liability and contractual liabilities are two separate issues under PRC law. You cannot exclude the liability due to tort by way of a contract.
Okay, fair enough. Excuse my thick Irish accent must have made the word hard for you to understand. Okay, continue, please.
Contract negotiation. Here we are happy to share with you some of our general observations on issues which should be taken account of by foreign companies during negotiations. First of all, you need to identify the key items before negotiation. To facilitate, obviously, what the key items are depending on what type of contract you are negotiating with your counterparty. For example, if it is a joint venture contract, you need to consider the issue of management control, capital requirements, land and facility requirements, which are necessary for the operation of the joint venture and how to acquire them, the allocation of main responsibilities between the foreign and the Chinese shareholders. I need to put forward a list of the various contracts and ancillary documents that are critical to the formation of the joint venture to the table for the parties to discuss them one by one. And knowing your bottom line, it's important for you to establish a bottom line for these key items and set up a clear timetable for the deal. Somebody needs to push for the deal to be done. So you need to set up a clear timetable and then stick to the timetable. Control the negotiation process. An organized negotiation process will help to shorten the length of negotiations and to facilitate a timely closing of the transaction. In many of the projects we have worked on, there were monthly meetings where the parties will meet face-to-face to discuss, clarify, and negotiate the contracts. After each meeting, we will prepare meeting minutes to discourage the parties from changing their positions agreed during the meetings. A list of the open items and positions of each party will also be prepared before each meeting to clearly identify the issues that need to be addressed for this meeting. Last point, it's also important to get your own interpreter. to avoid miscommunication between the parties, it's strongly recommended that each party has its own interpreter who is familiar with the industry and the business. We find that a single interpreter offered by one party to do interpretation for both parties sometimes will invite potential challenges from the other party and will create a conflict of interest issue. So just to get your own interpreter for your own side. Next slide. Before we go to this slide, maybe we can ask the third poll question.
We certainly can. Hang on, let me pull that up off the system here. That question is, have you had any disputes with a Chinese counterparty with regard to the performance of contracts that you have done? So let me just launch that. So if you've had any disputes in the past, just to get a feel for who's in there. Yes, no, or other. I had to put other in. I'm not quite sure what other means, but some people are clicking it. If you have any other experiences, then please feel free to share them with the group. Just another couple of seconds. Please have a click. Other, I suppose, means you haven't had a contract yet. I've just worked that out in my head. All right, just a couple more seconds. Bad news for the lawyers, it's looking like, Catherine. Most people have said no or other. Let me close that off and launch. Very bad news.
That's good. That's good.
Everyone's doing great business. Let me just share that with the group. So we're at 10 yes, 70 no, and 20 other. Back to you.
Okay. In terms of contract performance, it's important for you to document any amendments to the contract in writing. An extension renewal, as what I said, it essentially creates new obligations on the parties. And if you discover there's a breach by a counterparty, it's very important for you to preserve and collect the evidence about such breach, and asserting timely your rights. The statute of limitation for you to bring a lawsuit against the counterparty is 2 years, but there are certain exceptions. For example, if it's a dispute concerning personal injuries or non-payment of rents, these kind of disputes, you only have 1 year to assert your rights. In the end, I will speak a little bit more about the litigation and arbitration. There are some basic differences between litigation and arbitration. For example, litigation does not have to be limited to one court or one jurisdiction. Unless the parties submit to the exclusive jurisdiction of a particular court, the parties have some flexibility in determining the court and the particular jurisdiction. In the Chinese law, a Chinese People's Court has jurisdiction to hear major cases involving foreign interest, and the parties to a contract can choose a court where the defendant is domiciled, where the contract is performed, where the contract is signed, or where the plaintiff is domiciled. And even though you don't have a presence in China, Chinese court would still have jurisdiction over proceedings over brought in China against a foreign company if the contract is signed and performed in China, or the foreign company has a representative office in China. The second difference is that the arbitration award is final. It's final and non-appealable, although there are some limited grounds for which application can be made to a court to refuse or recognize the enforcement of arbitration award. These include a failure by the Arbitration Commission to comply with its procedural rules or the invalidity of the original arbitration agreement or provision. In any event, such grounds are very limited. A court judgment, on the other hand, can be appealed to a higher level of court unless the judgment was issued by the PRC Supreme Court already. The third difference is that fees. In terms of the fees, arbitration fees charged by arbitration commissions, no matter it's foreign arbitration or PRC arbitration, are likely to be higher than PRC court fees. If it is foreign-related, if it's a dispute involving a foreign-related contract, you have several options to decide how to settle the dispute. For example, you can choose to refer the dispute to PRC court, refer the dispute to foreign court, refer the dispute to foreign arbitration, refer the dispute to CTAC arbitration, or to local arbitration. It's not possible to formulate some hard and fast rules concerning the advantages or disadvantages of litigation arbitration, because the choice will depend on a lot of details of the specific transaction. But in terms of foreign litigation and foreign arbitration, arbitration is more preferred, because a foreign judgment will only be enforced in China if there's a treaty between the country where the foreign court is located and China in relation to the mutual recognition and enforcement of court judgments. Very few such treaties exist, and it's very difficult to have the foreign judgment recognized and enforced on the basis of reciprocity. But on the other hand, because China is a party to the New York Convention, so the arbitration awards given by a signatory to a New York Convention can be readily recognized and enforced in China.
Catherine, I've got a couple of quick questions, the same question from 2 or 3 people. What's the relationship between the UK and China in this case?
Unfortunately, UK and China does not have such a bilateral treaty on the enforcement of judgment. So, you should choose foreign arbitration instead of litigation in an English court. But Hong Kong has a bilateral arrangement with mainland China. So if it's a court judgment given by a Hong Kong court, it can be recognized and enforced in China.
Okay, I've got another question here from Simon. It's actually also about this topic. He wants to know what countries do have these relationships. I guess maybe this is a multinational company might have offices all over the place or something like that. They might be able to choose a place that's better to have a contract with.
That's a good question. Actually, we have never checked this issue because very few treaties, if there are any such treaties, exist.
Okay, we'll have to get back to Simon on that one. Over to you again, Catherine.
I think that completes my presentation today, so I will hand over to my colleague Hao to do a short talk on the PRC taxes part.
All right, terrific. If you've got questions, please drop them in. We've had a few, and I'll move on. Over to you, Hao Jiang.
Hi, everyone. This is Hao Jiang. Good to be here. I'm here today to cover the PRC tax regarding the commercial contract you potentially have with a Chinese counterparty. But before I get started, can we go to the fourth polling question?
We absolutely can. Let me drop that one in here now. Where is it? Oh yes. Are you using a tax advisor right now? Let me launch that. So please click on whichever one makes sense for you. So not bad news for the tax lawyer.
Okay. I guess the question is kind of obvious. If you are doing kind of business, you might use either accounting firm or law firm for tax advice. But in China, although I'm working with a law firm, we actually can provide a pretty high quality of tax service to the client. So just bear in mind. Okay, go back to the PRC tax presentation.
Sure.
So basically, I'm going to cover several key elements in the area of PRC tax, including the PRC tax laws, overview of PRC tax rates, PRC tax issue regarding various commercial transactions, general tax provision in commercial contracts, and the China-UK double taxation agreement. Next slide, please.
郝江, are you there?
Okay, yeah, I'm here.
It all went very quiet for a moment. I thought I'd lost you.
Okay. So basically, when we think about the PRC tax law, there are various legal authorities we look for, including domestic tax law, like enterprise income tax law and its implementation rule passed by National, People's Congress. That's something like a statute, in some Western countries. The second authority is double taxation agreement and interpretations. As we know, UK and China does have a double taxation agreement or DTA in place right now, and also the China state taxation, state administration of taxation has issued a very circular to interpret the double taxation agreement, not just between the China and the UK, and also between China and other jurisdictions. In particular, a couple of years ago, the China's the state taxation of state administration of taxation, or SAT, issued a circular to interpret the DTA between China and Singapore as a model for as a model interpretation for all kinds of DTA entered by China. So that's a second major legal authority we need to take a look. The third legal authority consists of anti-avoidance rule, including transfer pricing rule and other substantive and procedural requirements. For instance, if a UK company want to claim a tax treaty benefit under the double taxation agreement, although the DTA itself does not include any additional substantive or procedural requirements, the anti-avoidance rule basically provides that UK company needs to comply with the substantive requirements such as beneficial ownership rule and the procedural requirements such as filings or approval from the Chinese tax authority. Then the fourth authority we use some administrative tax cases in China. Since China is not a common law country, those tax administrative cases are by no means precedent, but still they are very important to us, so we can understand the thinking and the approach used by the Chinese tax authority. Okay, next slide.
Just while I'm changing slide there, Hajang, just be sure to speak very closely to the microphone, okay? Just one or two people had some issues, so
okay, sorry about that.
That's all right. Yeah, that's terrific. On you go. Thanks.
Okay. Then, if you ever do business with a Chinese company or Chinese individual, those are major PRC tax rate you probably want to grasp. The EIT tax rate on business profit is 25%. EIT basically means enterprise income tax. That's the income tax applicable to enterprise such as a corporation. The second major tax is business tax. Business tax generally applies to service or sale of intangible, or or sale of real estate, the BT rate varies. But in most cases, perhaps relevant to you guys, the BT rate is is 5% of the gross amount involved. The third rate, is the valued added tax rate on sale of goods. Let's say if you export a certain goods to China, then it's very likely that good will trigger a 70% import VAT rate. Or if you want to open a manufacturing facility in China and sell goods within China, then that entity could be either subject to the 3% VAT rate as a small-scale taxpayer, or 17% VAT rate as a general VAT taxpayer. And recently, there's a kind of the tax reform within China by subjecting certain service to VAT rather than the business tax, or BT. Under the tax reform, there are 4 layers of VAT tax rate applicable to those services. 3% basically mean applicable to small-scale VAT taxpayer. Then 6% applicable to qualified service. The qualified service right now just a portion of all service involved. Still, that means the majority of services still are subject to the BT or business tax. But those qualified services, including R&D, technical service, information technology service, culturally creative service, logistic, service, certification, and consulting service, those services are no longer subject to the business tax. Instead, they are, right now they're under the VAT regime. For instance, previously the legal service provided by a lawyer to client needs to pay 5% BT, but right now it's become to a qualified service, then potentially subject to 6% the VAT rate. The 11% VAT rate applies to transportation service, and then 17% VAT rate applies to the rental of tangible personal property. So those VAT reform was put in place just last year. Right now, they are only covering 9 cities in the province, including Beijing, Shanghai, Tianjin, Guangdong, Fujian, Jiangsu, Zhejiang, Anhui, and Hubei province. For all the service outside of those 9 cities and province, those services are still subject to the BT, business tax. Then comes with stamp duties. Stamp duty is kind of very small item, miscellaneous tax on contracts. Let's say if you have a sale of goods contract with a Chinese counterparty, and although the contract could be signed outside China, if you ever want to use the contract in China for some purpose, let's say for custom clearance or for receipt of tax clearance certificate, then you need to pay stamp duty. But it's very low. It's 0.03% of the total consideration in the contract. Finally, there's a transfer pricing issue. Transfer pricing issue only incurred between 2 related companies. Let's say if you have an entity in UK and that entity opens a JV or a subsidiary in China, any contractual dealing between your UK entity and that Chinese JV or sub would be subject to transfer pricing review. So those are perhaps the major tax and tax rates you would encounter in your business dealing with a Chinese counterparty. So perhaps we can go back to the fifth polling question right now.
We can. I shall launch that. And that question is: have you come across?
Okay, thank you.
Have you come across any PRC tax issues already? While I'm just waiting for people to vote on that, we actually did a webinar ourselves in early December on the VAT reforms. So if you go to the webinar section of the CBBC website, and I'll point that out at the end, you'll find a pretty technical and in-depth discussion on the VAT reforms. So please feel free. I think it's a pretty key thing. I think most of China will, well, all of China will ultimately go in that direction. And I think there's quite a lot of considerations between different industries and different areas in China. So I think this is a very technical subject, and one that I would certainly advise companies to get some help on. All right, so just
right, David, you're absolutely right. I mean, it's expected that within a couple of years, perhaps the most, if not all, the service industry will be put under the VAT regime rather than the current the business tax regime. Okay, next slide.
All right, so you can see that nobody's come across any PRC tax issues already. Hao Jiang, I hope.
I mean, that's pretty understandable, because I believe at the beginning of this presentation, during the earlier polling question, it seems like the majority of the attendants, they have not yet do any business, dealing with the Chinese counterparty. So that's pretty understandable. But of course, we are here to help you guys if you ever do come across, PRC tax question later on.
Terrific. Thanks, Hao Jiang. Okay, I'll change on to the next slide for you. PRC, okay. On you go.
Right, that PRC tax regarding various, commercial transaction or scenario. I just want to go to, just a little bit the depths regarding certain PRC tax issue in various, situations. The first is equity investment and exit. Let's say if you want to make an equity investment into China, that could be done through two ways. In either directly you open a JV or you open a sub in China, or indirectly if you let's say if you buy an offshore holding company over a Chinese operation entity, that's kind of indirect equity investment into China. In this situation, in the case of direct equity investment, you perhaps need to consider various elements or factors relating to tax. The first of all is always the choice of entity. What kind of entity you want to open? Is that a corporation, or is a partnership, or a branch, or rep office? Earlier on, the foreign investor tend to favor the rep office because the rep office largely didn't pay any income tax in China. But those days are over right now, and rep office have been forced to pay income tax, since I believe it's 2010, after issuance a new circular. So right now, perhaps the two most relevant choice entity are either corporation or partnership. Then you need to consider how much equity or debt you want to inject into the new entity, because we all understand that from a tax perspective, equity and debt, means a different tax, implications. For equity investment, you will get a dividend as return. For debt investment, you will get an interest, as a return. When you get either dividend or interest out, you could have, just different tax liabilities. Then you would consider what would be the optimal holding structure from a tax perspective. Whether you want to make a direct investment, or whether you do want to play around and choose an offshore holding company instead of them. Then when you receive either profit from or economic return from China, there's an issue as to how to get those money out. Whether you will get the money out as a dividend, interest, royalty, or just service fee. So those are various issues you would like to consider if you want to make a direct equity investment in China. Alternatively, if you want to make an indirect equity investment in China, nowadays it's possible that that indirect equity investment could also create a Chinese tax implication at the time of exit, because China considers some form indirect equity exit just as the direct equity exit, and that could trigger some Chinese filing obligation and tax liability. The second scenario is about import and export of goods. If you want to import goods as a UK entity or UK person from China, that is actually pretty easy stuff. That means the Chinese exporter has to dealing with those complex Chinese tax issue, but you don't have to. Alternatively, if you want to export an item into the Chinese goods, although the Chinese importer need to bear the Chinese tax liability at the time of the importation, such as the import VAT or custom duties or consumption tax, those Chinese importers tend to negotiate some kind of negotiate the price with you in order to take into account those Chinese tax. And sometimes there is also an opportunity of planning around that between the importer and the exporter. The third scenario is about a cross-border service. Let's say you want to provide a design service to a Chinese company. Then there is an issue regarding whether you would pay Chinese tax on the service fee you received. In that situation, the key question is whether you often send people into China to perform the service so as to constitute a permanent establishment in China. If you do have a permanent establishment in China, due to the presence of your employee or your staff in China, that permanent establishment needs to pay a Chinese enterprise income on its profits. Alternatively, if you still send someone into China, or if you never send people or employee into China to perform the service, then the entire profit you received as a service fee would not be subject to the Chinese enterprise income tax. So this is a big deal. You got to be very careful if you are engaged in providing the cross-border service to Chinese clients or customers. The fourth scenario, let's say a transfer of technology to a Chinese entity, then most likely that you will receive the fee from that transfer. That fee is often called a royalty. the royalty would trigger the Chinese tax liability. But sometimes it's just difficult to distinguish the service from the royalty. For instance, you assigned a technology to a Chinese company, and as a return, you received certain fee as a royalty from that Chinese company. But in the meantime, in order for the Chinese company to properly use your technology, it's often the case that you need to provide a service like a backup service or on-call service to their Chinese company. That combination of the fee for the technology and the fee for the service often create a headache. The Chinese tax authority, in some situation, in some cases, they basically step in, says that perhaps all the fee, even including the service component, would be treated as a royalty and subject to the withholding tax rate applicable to royalty. So in that situation, you definitely need to be careful about the scope of your technology transfer and the scope of your service, as well as how the contract drafting will reflect that difference. Next slide.
While you're there, Hao Jiang, I have a question from Jasmine. She just wants to know, could you just explain when the 3% VAT will apply and when the 17% will apply? If you could just go over that again quickly, that would be great.
Sure, no problem. First of all, it depends whether you are engaged in the service industry or not. Okay, if you are just selling goods in China, the threshold is I believe the annual sales amount of 800K RMB. So if you are above that threshold, that means that the company in China is going to pay a 17% VAT rate on the sale of goods in China. Otherwise, it will be subject to the 3% as a small-scale taxpayer. So just bear in mind that there is a revenue threshold on it. On the other hand, if you want to provide a service in China, it depends on what kind of service you are offering, right? And as we can see from the previous slide, if you are doing rent of tangible personal property, then the 70% would apply. Also, there is a threshold. That means the rental, the rental from the leasing the tangible personal property is over 5 million RMB. If you're below 5 million RMB threshold, then you will be subject to the 3% VAT as a small-scale taxpayer.
Thanks,
so
like with everything in law, I think or taxes, it depends, I guess, is the short answer.
Yeah, exactly. Right. I mean, but still, there is a threshold. Regardless of whether you are doing sales of goods or the service, there is a threshold. But the threshold kind of different. In sale of goods context, the threshold is RMB 800K. In the service area, let's say for leasing of tangible personal property, the threshold is 5 million RMB. Okay. Next slide. So there are some general tax provision we often see in commercial contract between foreign investor and a Chinese counterparty. The first one is, often something like each party will pay its own respective tax liability in relevant jurisdiction. That means if you have a kind of contract with Chinese party, let's say a service contract with the Chinese party, you will receive the service fee. That means if if you are required to pay Chinese withholding tax or income tax or whatever under the contract, it's your liability. You pick up the liability. You got to make a payment on it. But oftentimes the party can negotiate how to deal with the extra tax burden. One common approach is to do a tax gross up. That means, let's say, if initially your contract price is 100, then you need to pay the 10 tax, on the contract. That add up to the 110, right? So in the negotiation, you can basically request the Chinese counterparty to pay you, let's say 110 upfront. That 110 will generate the 10 tax, due to the Chinese tax authority with a net amount 100 still to you. So that's a kind of common approach you can use. But it also depends on what kind of situation you are in. Only if you have leverage with the Chinese counterparty, you can basically pass on those tax liability to the Chinese side. Otherwise, they kind of want to push back against your request. The third provisions regarding the tax reporting and the filing obligation. Oftentimes, in the contract, we'll say each party will, will make its appropriate filing with relevant tax authority. That most time is not a problem, but in the case of indirect equity transfer, that could be a very huge challenge, because because of several reasons. One is that the rules are kind of unclear. There's no adequate interpretation or explanation of the rule issued by the Chinese tax authority. The second is that the foreign investor, generally speaking, don't like or don't agree with the basic logic underlying the filing or reporting obligation as to the indirect equity transfer. So in that scenario, it could be kind of complicated thing to negotiate between the two parties. Fourth is escrow amount. If there is a tax contingency, that means something could or could not occur. Then it's possible the party agree to put the extra tax money into an escrow account for some time. After the time lapse, the money could go back to the original party owner if it's not paid to the Chinese tax authority. The fifth is tax clearance certificate. That often occurs if you receive the money from China. Since the Chinese party need to send the money to your offshore account, the Chinese party need to go through various procedure requirements, including the foreign exchange clearance as well as tax clearance. In China, if there is no tax clearance certificate presented, then the bank simply will not transfer the money for you. So it's a real issue, and you need to always take that into account, especially when there's no withholding agent in China to help you to do this tax clearance certificate. Sixth item is the tax indemnity. That means if the other party misrepresent or or fail to discharge its obligation in the contract, if there is any tax loss, then the other side is obligated to indemnify you against the potential loss or liability. The final item is tax assistance. That means the two parties will reasonably cooperate with each other to dealing with any emerging tax issue, let's say a tax inspection or tax audit notice issued by the Chinese tax authority. Next slide.
I'm conscious of time a little bit, Haojiang, so let's move along swiftly. Thanks.
Okay, sure, no problem. So the last two slides basically covering the China-UK DTA. Right now, there is a DTA in place between the two countries, and that DTA entered into force in 1985. As you can see, there are various rates regarding the various income stream. For dividend, that 10%, interest also 10% withholding. Royalty, if it's regarding a royalty fee arising from leasing of industrial, commercial, or scientific equipment, then that's 7%. On the other hand, by the default, the withholding tax rate on royalty is 10%. There's a pretty unique provision in the current DTA regarding the technical service fee. There's a standing alone provision provides that their withholding rate is 7%. Then next slide. China and the UK renegotiated DTA about 2 years ago, but that DTA has not yet entered into force. In the DTA, as you can see, the dividend withholding rate has been reduced somewhat. In the case, if let's say one side owns more than 25% equity interest in the other side, so the 25% threshold is very important. Let's say if you has 10% equity interest in a Chinese entity, then you need to pay 10% withholding rate on the dividend received. Alternatively, if you has let's say 50% equity interest in a Chinese entity, then the dividend received will be paid by the withholding tax rate on dividend will be reduced to 5%. So that's an improvement from the previous DTA. On the interest side, there is no change. On the royalty side, the withholding tax rate on industrial, scientific, and commercial equipment has been further reduced to 6% from 7%, and the real change happening to happens to the technical service fee. That provision has been deleted. Instead, there's some kind of language under the permanent establishment clause regarding a service permanent establishment. That means if you send someone to perform service in China for at least 183 days within any 12 months period of time, the presence of your employee will create a service permanent establishment in China. Then the profit received by that service permanent establishment will be subject to a 25% enterprise income tax. So that's a pretty significant change. That brings the UK and China new DTA basically to the mainstream, to the mainstream practice. And perhaps we can use up the final polling question due to the importance of the recent VAT reform that changing the VAT, changing the BT to the VAT on certain service.
Yeah, I've launched that now. Just make sure people are familiar with the different types of taxation.
By the way, do you guys have indirect tax in the UK?
Yikes! You know what? I'm not a tax guy.
Okay.
I'm a government dude. They hand me a check.
Okay.
And I spent the last 10 years living in China, so I have absolutely no idea how anything works here. But I hope that somebody might type it in on the screen there. All right, we're nearly there. Oh, it's about 50-50 for this.
Okay. Yeah, that's nice actually. Um, just I think the basic point is that if you are going to do a service contract with a Chinese counterparty, then you could be potentially subject to the VAT in the long run rather than the BT. That VAT regime right now is still under development, but it could be very complex over the time. So just be cautious. That completes my part of presentation. Now I will turn to Catherine.
All right. Well, thanks for that. Yikes, a lot there. My brain is certainly a lot fuller than it was about 90 minutes ago. I have one question that a few people have asked. I paraphrase a little, but essentially it comes through Angela. She said, I guess she hasn't done too much business with China before, but she said, is it true that contracts are less important than personal relationships, and what does that mean?
Well, I totally disagree with that. I think this is a very old-fashioned way to think that contracts, personal relationships are even more important than contracts. Well, you may think in this way if the relationship is good and hope it will maintain in this way forever. But whenever, even if there's an issue, I think to have a properly drafted contract is critical to you.
I guess she's getting at the heart of what would be a question, yeah, a bit old-fashioned, but still kind of relevant. In terms of if you run into dispute or if you run into difficulty, how confident can you feel that the contract is valuable, and maybe that the legal process itself will support that contract? I think it's a fair question when put in those terms. So, Catherine, do you think that contracts are, the strength of contracts in a legal sense is stronger now for a foreign company than it was before, or what would you feel about that?
I think I think foreign companies are definitely not prejudiced in any domestic Chinese court or arbitration process. It all depends on the merits of the contract and the evidence you have about the other party's breach. So if the contract is properly drafted, it's validly binding and effective on both parties, and you have very clear evidence about the other party's breach, I think there's a very strong chance that your rights will be enforced here in China.
Okay, all right, fair enough. I have a couple of other questions, but I don't think they're relevant to the group. They're kind of specific, so I'll probably follow up afterwards with those people. Other than that, I don't have too many other questions, and I'm a little conscious that we've gone over time a little bit. So, Catherine, Haojiang, have you any closing things that you'd like to say?
No, thank you very much for your attendance today.
Yeah, great. Okay, well, thanks very much to Catherine and to Haojiang, who are in Beijing. I guess it's, 7 o'clock, so you guys need to go home and get your dinner. So have a great evening, and thanks for your time. For those of you who are still with us, I'd just like to draw your attention. I said a little bit before that we have a webinar on PRC VAT reform. So if you do like this webinar platform, if you go to our website at What We Do at the drop-down and click on webinars, you'll find all of our resources. Register for upcoming sessions, and also link to past recordings. So if you've got a colleague or friend who you think might have benefited from this, or you didn't catch it all first time round, you can feel free to have a look at either the PPT or the recording. Terrific. Okay, the last thing that remains for me today is just to point out some upcoming events. This week, on the 28th, we have a members briefing on the UK visa service in China, and that will be in our offices here in Victoria. It's obviously a big issue at the moment. It's hit the media quite a lot, so we'll have a speaker from the UK Border Agency to talk a little bit about that. I do think that event is actually fully booked. It's an extremely popular event. Our next webinar is the second in our IP webinar series. This one's in technology transfer. 12th of March, we have a business clinic in Plymouth. If you're down in that part of the world, please feel free to come along. March 14th, our big event for this quarter, which will be the China Business Conference, which is in the QET Centre in Westminster. Please keep an eye out for that. On the 25th of March, I would draw your attention to a CBBC roundtable on the proposed Sino-British Industrial Park in Chengdu in Sichuan. Now, there's also different events in Beijing and Shanghai. If you're China-based, just contact me about that. This is about an investment opportunity for a Sino-British Industrial Park. If you're keen to get involved in that, please contact us. And then we have a couple more webinars coming up. One on the 3rd of April, guidance for the UK education sector and setting up in China. And finally, the third of the IP series, which is IP protection exhibitions and trade fairs. All right, please have a look at our websites to find out more information about upcoming events and upcoming activities. Other than that, I'd like to say thank you very much again to our speakers. This was a pretty dense topic, a pretty important topic. I don't think anyone in China, in the UK or China, does business without contracts. So thank you for your time. If you want to watch that again, I shall post it on the website today. So thanks very much. Feedbacks and suggestions to myself, David Martin. If there's any topics that you'd like us to cover on this platform, if you have any feedback, any thoughts, or if you have any questions that you'd like me to pass on to the speakers today. So thanks very much. Have a great day, and hopefully see you at the next webinar. Bye-bye now.